right now, I wanted to focus a little bit on gun carry. You brought that up earlier. One of the things that you've been writing about and sort of warning about, or at least uh, talking about how it's been undercovered, is the New York's new gun carry law and the way that it sort of flips the presumption of where it's lawful to carry a firearm. So in every other state, it is presumed that you can carry inside of a public business if they don't post a sign indicating otherwise. But now in New York, they've done the exact opposite of that. Now it is a crime to carry, and also a lot of states don't make it a crime to carry where it's posted necessarily, at least not that isn't a specific crime in a lot of states. But in New York, it will now be a crime to carry in a location that doesn't post that they want people to carry there. And this is a pretty significant change and I guess innovation in the gun control space, and one that you think is, this novel approach is going to be challenging for gun rights advocates. Is that right?
I think it's going to be very challenging for them. So Second Amendment is a claim against the government. It is not a claim against private businesses or other private property holders. And so, it's pretty clear that if private property owners want to keep gun owners out, they can do so. The question is, how do they do so? Is the default rule going to be that you're allowed in unless you're told to leave? Or is the default rule going to be that you're not allowed in unless you're specifically invited? And, the default property rules have been traditionally that in private homes, you really should be invited onto the property unless you're just walking up the door to knock. There's often an implied invitation for that. And that for businesses, it's the opposite, that you can come on unless you've been excluded. There are a few states, including South Carolina, I think, and Louisiana, that say you can bring your gun onto private businesses unless you're excluded, but you can't bring them into somebody's home unless you ask permission. So some of the pro-gun states have some sort of restriction, at least in some cases, saying that there's a presumption that you're not allowed to bring it in. Now, the New York innovation is to combine private property with the power of government by saying you are presumed not to be able to bring it in anywhere, and you're going to be guilty of a felony if you do so, not just a trespass. And I think this is a very hard issue, because it is for conservatives. It's at the intersection of gun rights and private property rights, both of which they believe in. In terms of the Second Amendment doesn't. There's been very little law on what the presumption has to be. The closest analog I can think of this is that Alabama in the early 1900s prohibited possessing a pistol on property not one's own. And the Alabama Supreme Court actually upheld the prohibition. So that's the only case law that I think is analogous to this. But I'm not sure the Second Amendment says anything about what the default rule is either way. And so I think gun rights advocates, from what I've read online, I think that this is an easy case because the practical implication is a de facto ban on public carry, which it is.
Right.
But I don't think it's quite that easy given how they've co-opted private property. I think it was quite an ingenious way to do it. But I'll let you follow up with that. But I have more to say on why it may still be unconstitutional.
Yeah, I definitely want to hear that. I just, obviously I think the main argument is that you've seen mostly is gun rights advocates focus on the fact that this law is really an attempt to just make gun carry off limits everywhere, in basically a direct
and they've in fact done that. People in upstate New York are far worse off today than they were under Bruen, because before Bruen, licensing policies were at the local level, and at least geographically, most of the counties were shall issue in practice. And the irony of the may issue states was always that it was uncertain and potentially difficult to get a license. But once you got a license, you had pretty wide freedom of what you wanted to do with it. That guns were always more restricted in the South and in the pro-gun areas than they were in a lot of the may issue states. It was hard up front, but once you got through the gate, There were no restrictions on bars or public transit or any of this. States have come back, and a person who has an unrestricted pistol license in upstate New York after Bruin and after this law is far worse off than before Bruin.
And you saw Governor Hochul there, the Democrat, basically say that admit that there'd only be a few places where it would be legal to actually carry a gun after this law went into place, especially in New York City. And so that, I think what people in the gun rights community have noted is like that is just a complete and total, middle finger to the Supreme Court, because they're basically just doing exactly what the court told them they can't do. And so I think people view this flipping of private property or public business access on its head to be part of that, and just consider the whole law to be unconstitutional. And there hasn't been a whole lot of discussion about why that particular novel approach is unconstitutional. So, I am interested in what, now that you've laid out the risks, why do you think it's not necessarily going to stand up?
I think there's a middle approach here. So, the kind of two stock positions right now are that either it's constitutional because the default rules aren't constitutionally mandated, or gun rights advocates are challenging these laws and saying, well, there's no historical tradition for doing this. But I think there's a middle approach here that, what New York is doing in some ways is analogous to how Southern legislatures acted after Brown versus Board of Education ordered the desegregation of schools. And so what you saw after Brown was massive resistance, including legal resistance in a few different forms. Now, what's interesting about the New York law is the New York law does not actually flip the presumption. We've been saying this, but it's not actually true. And if you look at the law is heavily gerrymandered. So the law does not apply to police officers or other law enforcement officers, including those who are off duty, and it doesn't apply to retired law enforcement officers. So the law is gerrymandered only against license holders. Now, if you really flip the presumption, what that would mean is that no one would be authorized to bring a gun without explicit consent, except for officers who were justified in committing what would otherwise be a trespass. So an officer who had a warrant or was in hot pursuit of a felon could go onto private property without the owner's permission. But a police officer getting a coffee and a donut on a break would have no authority to go against the private property owner's wishes. And with, a fortiori, an off-duty officer, and even more so, a retired officer who has no law enforcement powers whatsoever, has no authority to go on private property against the owner's wishes. So if New York were truly flipping the presumption, then the presumption should apply across the board, except in those cases where the officer would be justified in committing a trespass. So they've heavily gerrymandered this law. And I think that's somewhat analogous. If you go back to what the southern states did after desegregation, the orders came down, there were a couple different versions of this. And one version is some of the states passed laws saying, well, we're going to abolish public schools. But when we abolish public schools, we're going to give you tax breaks for private schools, and there's going to be a lot of government participation in these private schools. And the Supreme Court said, no, you can't evade the desegregation order by, quote unquote, privatizing your schools while still maintaining what are, in essence, de facto public schools that they have heavy participation. And on the other hand, there was a case that involved the desegregation of public pools where Jackson, Mississippi said, well, you know what, we're not going to run a pool system at all. It doesn't matter what race you are. We're out of the pool business entirely. And the court said, well, if you're out of the pool business entirely, we'll let you do that because you're not required to run a pool. You're not required to run public pools. And we realize that some of the people who voted for this had pernicious motives. Some others may have legitimately believed that the pools wouldn't have been economically viable. We get that. We're not going to go into the motivations that much. If you're going to have a neutral law that says no pools for anyone, fine. But if you're going to gerrymander your law to create a de facto public school system that has the guise of private schools, that just violates our remedial decree, and we're going to order you to stop doing that and to reinstate the public schools. And I think that middle position may have considerable validity here. If New York really wants to flip the presumption, it can do so, but it has to actually flip the presumption and tell law enforcement officers, no, you cannot go onto private property unless you're invited. But if they're going to gerrymander the law only to make it impossible for license holders to carry guns in public and no one else, that just seems like a flagrant disregard of Bruin. And so it may not be all or nothing. There may be this middle ground, and this middle ground may be advantageous to gun owners because, of course, there may not be the political will within the legislature to tell retired police and others and off-duty police that, no, you will commit a felony if you bring your gun on private property without permission. So I don't think this is an all or nothing thing. You're right that they are thumbing their nose at them, but there is a kind of precedent on how you handle this. And so there may very well be a middle position here that is not one or the other.